What happens when a state fails to meet its constitutional obligations to provide all students with a sound, basic education? If a court tells the state that it's failing to appropriately fund public schools, how do we fix it within our system of checks and balances? Is 30 years enough time to answer these questions?
You would think that a few years tops would be enough time.
I think we can do it. I think we're going to do it in about 60 minutes.
You know what? With 3 professors on this thing, I would be really surprised if we hit it in under 60 minutes. But let's do our best.
We're going to do our best. We'll see what happens.
Well, so the reason why Chris mentioned 30 years, everybody, is because this case that we're going to talk about today, it's not over yet, but it has already been going on for over 30 years now in North Carolina. So we're going to dig into it in just a few minutes.
Welcome to Chalk Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. Now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Chalk Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
So welcome back, everybody. Today we are joined by very special guest and school finance expert and all-around super dude, Dr. Eric Houck. He is here today to help us make sense about this long-running case here in North Carolina that is affectionately known as the Leandro case. This is North Carolina's decades-long school finance right to a basic sound education case. So we are thrilled to have Eric join us today. Eric is a professor of educational leadership and policy at the University of North Carolina at Chapel Hill. He is the past president of the National Education Finance Academy. He has published countless articles, a number of books. He just recently published a book on school funding in the United States, Indian country, and the U.S. territories. He is a great guy, funny guy. I had the pleasure of working with Eric when I was a PhD student at Chapel Hill. This guy knows what he's talking about, and he's got great taste in movies. Welcome to the show, Eric. Thank you so much for joining us.
Thanks, you all. I really appreciate the introduction. I'm going to try really hard to live up to it. Fun fact, I wrote my master's thesis on the Leandro case in 1999.
Oh, my goodness.
Really?
Yeah.
You know what? It's so funny because I had no idea. And when Chris and I were talking about, like, we've got to do another school finance case, and there's so many of these cases taking place in states all around the country.
Yep.
And Leandro is such a fascinating yet frustrating case. Yep. But it's a great exemplar case. And when we talked about doing it, I was like, well, we got to have Eric Houck on the show. And I had no idea that you wrote about this.
Yeah.
Right after it kind of started.
I should get a bumper sticker that says Leandro is my job security.
Well, there might be a ruling pretty soon, and hopefully you'll still have a job.
This is none of this is going to get, we're going to solve it.
Yeah, we got it all figured out.
Every state has one person, right, who knows the funding mechanism inside and out from an academic perspective, and that's you. That's job security. Yeah, absolutely.
Yeah, well, we're glad to have you, and I think we should get into it.
Yeah, but before we do, Jamie, do you have a bell ringer for us?
Yeah, you know what?
To put it a different way, given everything that's going on in education right now, which bell ringer did you choose?
That's a great way to put it, Chris. It's like
drinking from the fire hose right now.
That is another great way to put it, Chris. You're on fire today. Nice.
Yeah, and I didn't even get nearly the generous introduction that Eric got.
Everybody knows you now. All right. Yeah. So I've got a couple of cases I want to highlight. Interestingly, back in sort of the second half of January, the Supreme Court decided to take up a couple of cases that people weren't really, I don't know if these cases were really expected to be taken up by the Supreme Court, yet here we are. And so these two cases that the Supreme Court has decided to take up also goes to show how on top of things Chalk Gavel is.
Right? We are nailing it.
So the two cases, we've got Mahmoud versus Taylor, which used to be...
Episode 12.
That was episode 12. It used to be Mahmoud versus McKnight, but McKnight is now no longer named in the suit. So when we covered it in episode 12, it was Mahmoud versus McKnight. And that was the case about the parents who objected to the LGBTQ inclusive books that the school board adopted as approved parts of the curriculum.
Right, because and if you remember, the school board removed the ability of parents to opt out of that curriculum. And that was kind of the sticking point.
Right.
Yeah.
Right.
Yeah.
And one of the interesting things we mentioned in that case was how that school board reversed their decision in 24 hours.
Right. Yeah. There's some communication conflict.
Yeah. They were like, okay, you guys can opt out of this. And then like the next day, they're like, you know what? We take that back. So that decision was appealed to the Supreme Court and they granted cert. And they haven't set an argument date, but it is possible that it will be in April. By the time this episode comes out, my guess is we'll have an argument date for that. And then the other case that is, and both of these cases potentially have huge implications for education. The other case is one that we talked about in episode 23, which was the Oklahoma statewide charter school board versus Drummond. This was that case about the Oklahoma's charter school board. They granted a charter for a religious school. There were a number of challenges, and it went to the Oklahoma Supreme Court, which was when we covered it in episode 23, we covered the Oklahoma Supreme Court ruling, which basically struck that down, did not allow that to happen.
Said under Oklahoma law, you could not have a virtual religious charter school.
Yeah. Yeah. And so, that the charter school board sent that up to the Supreme Court, and the Supreme Court said, we're going to take that up.
Right. Yeah. So this is shaping up to be a pretty huge education term because we've got these two cases about education. We've got a couple other cases about like LGBTQ individuals and issues.
Yep. There's an IDEA case or an ADA case as well that's coming up.
And that's why I was surprised that the Supreme Court took both of these because usually they don't take multiple education cases at the same time. And it's also these are really tough questions because the Mahmoud case raises issues of parental rights, student rights, LGBTQ student rights. Yeah. And then the Oklahoma statewide charter school case, that is a fundamental question about the role of religion in public schools, which has been a streak of cases from the Supreme Court. But a lot of people have said, is this one step too far? So it's just really interesting to see the Supreme Court take both of these.
Yeah. So, stick with us, Chalk and Gavel listeners, because chances are we're going to have an interesting episode coming out sometime in the summer.
We covered them once. We'll cover them again.
That's right. All right. So that's our quick little bell ringer for today. There are plenty more. If anybody has any sort of education news feeds that they subscribe to, I'm sure you're getting inundated with things.
Let us know if there's stuff you want us to cover.
Yeah, don't hesitate to reach out. We're always looking for ideas. Okay, so are you ready to dig into Leandro?
So ready.
Very ready.
Excellent. Well, we've got this sort of massive timeline of events that start in 1994 and have continued up to the most recent big event was arguments that took place at the North Carolina Supreme Court in February of 2024, so about a year ago. A lot happened in those 30 years, and we're going to talk about some of those highlights. We're going to talk today about how school funding works, because this is a complex case, right?
It is. Yeah.
Yeah. And so we'll talk about the case, but we'll also talk about how schools are funded and why stuff like this is so complex and often frustrating, because at the end of the day, the very ultra short version of Leandro, and please jump in and correct me if I'm wrong, Eric, is that we had an accusation that groups of students, mostly in the rural areas, were not being provided a constitutionally guaranteed, North Carolina constitutionally guaranteed access to a sound basic education. They were not getting what they needed to. And on a number of occasions, the courts kind of agreed with that. And then everything got so complicated when it sort of devolved into, okay, who is responsible for remedying this particular injustice? Is that?
Yeah, I think there's complexity about levels of governance, right? Yeah. There's complexity around separation of powers. And I think, although you're factually accurate that the definition of what a sound basic education was defined by the court, that definition was so broad as to basically cast the entire system into question.
Yes.
Right. And so I think it's a lot of trepidation by a lot of actors to fully step into what the court in 97, like a million years ago, right, defined as the parameters by which we determine what a sound basic education was.
Right. Yeah. And these are things that like all 50 states, or maybe not all 50 states, but most states have dealt with school funding litigation, and they've all had to answer these questions. Like, there's a number of questions. I almost think of them as like kind of checkpoints where like, what does the Constitution say? Does it guarantee a right to education? If it does guarantee a right or an entitlement to education, what are the contours of that right? And then is the current system meeting those obligations? And if it's not meeting those obligations, how do you fix it?
Right.
And like, there are complexities in every single one of those questions. And even at the very top, there's the question of like, is this something that state Supreme Courts can even look at? Because typically this is something like education and education funding and education policy is something that we give to the legislative branch, and by extension, the executive branch. So like, is this something that courts can even wade in on?
And if they do want to wade in on it, then I think what the North Carolina case points out in other cases as well is like, what do they have to back up their claims, right? So what makes Leandro interesting from a national perspective is the real strain on the separation of powers, right? So if the court says that something needs to happen and the legislature says, no, thank you, what is the next step?
Yeah.
Right. Yeah. And that's like Leandro answered that question, which as far as I'm aware, like that's the furthest any Supreme Court has ever gone in answering that question.
Right.
So yeah, like when Jamie pitched this, I was so excited to talk about this case.
So this whole thing started in 1994. So I was in 1994, well, it depends on when in 94, but I was a junior or a senior in high school. And I was outside of Atlanta. So I knew not, I was a junior and senior in high school. Like I knew nothing about what was going on in my own state politically for the most part, let alone North Carolina. What were you doing in 94, Eric?
I was a classroom teacher in the Charlotte-Mecklenburg school system in Charlotte, North Carolina.
Okay, interesting. So were you aware of Leandro?
I was not aware. I was not aware until I was in graduate school, casting about for something that might be interesting to study. And frankly, at the University of Wisconsin and a little bit homesick, right? So it's like, oh, my home state had this case. Just to kind of give like a policy context, this is sort of the burgeoning of the standards-based reform movement, right? So accountability, assessment, policies are coming on board. North Carolina was big into that. And I think that is one of the parameters that defines how we move forward, like with the 1997 ruling.
Yeah. And the school choice movement was really taking hold in the 90s. Yeah.
Yep. We had a joke in the 2000 election. I was working in policy in North Carolina, and that was Bush versus Gore. And so the scuttlebutt was, if Bush wins, we're going to do Texas-style ed reform. And if Gore wins, we were going to do North Carolina-style school reform, right? Because Tennessee and North Carolina are closely connected. Yeah. North Carolina had a Democratic governor very much on the national stage. As the election got closer, I think most folks thought it was going to be close, but that it would tip towards Gore. And you'd go to like all the copy shops in Raleigh, North Carolina, and like there's just no resume paper. right? Like all the education policy people are like burnishing up their CVs, getting ready to dive in because, North Carolina and Texas were seen as sort of really on the bleeding edge of what you could do with establishing an assessment policy, linking it to an accountability policy, and kind of driving that vision for standards-based reform, right?
Interesting, which led to No Child Left Behind.
It felt very, very pre-No Child Left Behind.
Yeah,
for
interesting.
Sure.
And what were you doing, Chris, in 94?
I think I was in first grade, sir.
You guys are killing me.
I enjoy being the youngest person on this podcast, so I'm glad we're going to keep that streak going.
So while Chris was in first grade, we had our very first ruling on the Leandro case. So that was, what was it, Eric? It was like 5 school districts, rural districts in North Carolina, roughly?
It got complicated right out of the gate, right? So the plaintiffs originally were, 5 relatively rural, relatively low-wealth school districts. They were joined by 5 urban districts who came in as plaintiff interveners, right? Basically saying, well, the same arguments that these low-wealth districts are making about underfunding, we have as well, right? We see structural flaws in the system. I think the phrase they use, like municipal overburden, was not addressed by the school funding mechanism in the same way that sort of low wealth issues weren't addressed in the school funding system, right? And this was anchored in this kid, Leandro, who resided in, I forgot which one of the 5 low wealth districts, but kind of personalized the case, right? As we roll forward, kid actually ended up being able to attend Duke, which was sort of a little problematic wrinkle if you're arguing that the school system is ineffective and underfunded. If your plaintiff gets accepted to Duke University, that's just some of the fun stuff. So it was really, a larger group of districts making multiple arguments about the efficacy of the school funding mechanism in North Carolina.
Right. So in the 90s, how was North Carolina funding its schools? Was it based primarily on like local property taxes?
Yeah. So no, right? So if you go back to I always go back to the bangers, right? The old hits. So Elazar's work on political cultures of states, right? Kind of categorizes southeastern states and North Carolina in particular as being very paternalistic, right? And the school funding mechanism in North Carolina reflects that. It's like 60% state funding. Then, of course, you have your federal funding and about 30% local.
Interesting, which is kind of flipped from the national average, which is about 10% federal, 50% state, 40% local. So I guess you're close to it, but it's a little bit more centralized funding then.
Yeah, I always kind of say the North Carolina is the anti-Pennsylvania, right?
Okay.
Like the numbers are reversed between state and local.
Which they just had their own school funding litigation too, right?
Yeah. Exactly, right. Yeah. And so, the other thing that's interesting about North Carolina that we argue about to this day is that North Carolina has what they call a resource allocation funding model, one of 7 states in the country that do this. So what the state's actually allocating are the resources that school districts need to operate based on a per pupil count. They're not allocating dollars, right? So sort of show me 12, as I don't have the ratios, right? Show me 24 kindergartnens and we, the state, will pay for your teacher, the teacher that's teaching those 24 kindergartners, right? So it's a series of ratios that determine classroom staffing levels.
Gotcha.
Then you have a little bit of, categorical funding, and then you have some other added on components that are more formula based to address some inequities within the system. Some of which have been developed as a result of Leandro dragging on for so long. The state basically saying, hey, if we put something in our funding model mechanism to address low wealth schools, maybe we can make this go away, right?
Interesting.
So
that paternalism, that seems to be the fact that the state is saying we're going to fund the things that you need, but we're not going to give you the money so you can pick those things yourselves, right?
Yes,
that's really interesting because Florida does a per pupil kind of foundation amount, but they just get that to the school and then the school figures out how to spend it.
Right. And there's some ongoing debate about how much autonomy does this give folks. When people try to talk about changing it, one of the voices that comes up frequently are school finance officers in districts who kind of love this model.
Yeah.
Right. They don't quite have as much autonomy as their colleagues in other states, but also they have less burden.
Yeah. It makes things easier.
Right.
Yeah, for sure.
Yeah.
The universe of available decisions is much smaller.
Yeah.
Oh, I love that phrase.
Right. Yeah. Look at that.
So we've got this lawsuit. So the school district, the students from these school districts are suing the state, basically saying you're not giving enough money?
So, yeah, it's a tough case to make. So this was definitely what we would call an adequacy case, right? So it's based on the language in the state constitution that defines the quality of the education students are getting. There had already been a case arguing that school funding was inequitable. That was Britt versus North Carolina back in the 70s, I think.
Oh, yeah.
So the argument was you can't make an equity argument again because the court has already spoken to that.
Right.
And so this was an attempt to parameterize what the North Carolina Constitution said about the quality of education students should receive.
Gotcha.
Which they kind of phrased, it was phrased as a sound basic education, right?
That's
Eventually,
the phrase that becomes, that's the tattoos everybody has.
Yeah.
Who worked on the case, right? Sound basic education. That's the,
Hey,
right.
If I won that case, I'd do it.
Right.
But like, so you're talking about these different waves of education litigation. And so like, going back to the Rodriguez case, the United States Supreme Court, San Antonio v. Rodriguez, like that was the one, Jamie, you and I covered that in, I think, episode 8, maybe.
Sounds good.
Yeah.
8, 9,
someone will correct us. But, that's the one where the United States Supreme Court looked at a school funding question and said, like, does federal law say anything about how states can allocate their resources to fund schools? Because we had a bunch of low wealth districts in the San Antonio area arguing that the funding was inequitable compared to, other districts. And the Supreme Court, United States Supreme Court, came back and said, there's no federal right to education. This is completely a state issue. And so we saw states, across the country, like kind of take up that call and say like, well, wait, our Constitution says that we have a duty to provide education. Yeah. And all 50 state constitutions have something like that. To have an education clause, they're all a little bit different. And so we saw those two kind of flavors of litigation. We saw equity lawsuits and we saw adequacy lawsuits. One saying, my education isn't as good as someone else's. And then the other one saying, my education isn't as good as you're required to provide.
As your standard.
Yeah. And so, so this was an adequacy case.
Yeah. Right. Okay. Around defining what a sound basic education was. Right.
Right.
This wasn't too far removed from the 1989 case, Rose versus Council for Better Education in Kentucky.
Yeah.
Which is sort of like the proto-adequacy case.
Right. Well, and we're getting ahead of ourselves, but Leandro, like, actually steals Kentucky's homework, right?
Exactly. Exactly. Those definitions, which I've never seen the paper, right, that one of us should have written or could still write about sort of the lateral sort of consensus building across courts. Right.
The policy diffusion of the Rose standard. Yeah.
Yeah, exactly. Right. How that becomes like a de facto adequacy standard.
Yeah.
Even though states have their individual constitutions.
Right. Which all have different language too, right? Like,
right.
Yeah. So 94.
Yep.
We do this thing. And then what's the first decision? Like, does the trial court?
It was 97. The court picks it up and they end up handing it to Justice Howie Manning, who sits on it for a while.
Got it.
The 97 court sort of established this idea that the definition of a sound basic education, which they stole from Kentucky, can kind of be parameterized around how students are performing on end of grade, end of course assessments.
Got it. Which goes into what you were saying about accountability.
Exactly.
Yeah. Okay.
Exactly. Right. And so nobody really, and again, I'm imputing some of myself into this, right? But basically people got a little nervous, I think, because then you're basically saying if a kid doesn't perform at or above grade level, you haven't met the constitutional requirement.
Yeah.
Right?
Yeah.
And so I don't know anybody who wanted to go all the way there.
No, well, because then every single state wouldn't be meeting their,
right. Because somebody's going to not pass the test, right?
Yeah.
Exactly.
Yeah.
Right. And so if you want to say anybody who doesn't pass the test wasn't provided a constitutionally adequate education, you're going to be looking at a whole host of lawsuits, problems, and a funding model that would kind of have to guarantee something that would be really difficult to achieve.
Right. And it's really hard to guarantee outcomes, right? So like,
yes,
you see a lot of these things phrased as like opportunity to obtain an education that like is reasonably calculated, to use some special ed language, right?
Right.
Yeah.
Exactly.
Yeah. So the first big case is the 97 case that you're talking about, which is like what I think the North Carolina folks are calling Leandro 1, right? So this is the first time that the North Carolina Supreme Court is weighing in, because the trial court initially said there is a right to an adequate education under the North Carolina Constitution, the appellate court comes back and says,
they shot it all
not.
down. Yeah.
Right.
Yeah. So in 96, the appeals court shot it all down. And in 97, the Supreme Court agreed with the Court of Appeals, but rejected that claim for funding equality. Right. And so essentially they were pretty much just saying that the state wasn't meeting its constitutional obligations. And they tossed
and I think that Leandro 1 decision is so fascinating from a legal perspective because of those questions that I kind of laid out at the beginning of the case, or the beginning of the episode. Like, is this a question the court can even look at? If it is a question, how do we define the right or the interest at stake?
Yeah.
Is there a violation? How do we decide if there's a violation? Like, all of those questions, every court has to answer those differently. And like, we see a ton of courts answering them very differently. So like, that first question of like, is this something courts can look at? Or is this a non-justiciable political question?
A non-what, Chris?
Yeah, I practiced saying that before we recorded. Yeah, right. Oh no, now you got me in my head. Non-justiciable. There it is. But basically, like, is this within the authority of courts to answer? And, the North Carolina Supreme Court answered it very, very, let's say, succinctly, because they just said, yes, it is.
Well, and then didn't they kicked it back down to the trial court, right?
Well, they kicked it back down to the trial court to decide if there had been a violation. Which is something that you can only do if you decide it's a justiciable question. Right.
Got it. Yeah.
And so like the justiciability looks at whether or not this is a case that the court can fix. Right. And so like they're asking, is this something that has been entrusted to another branch of government? And a lot of state courts, particularly in the South, have said, yes, this is not something the courts deal with. Like, we don't do education funding. That is a duty for the legislature. Another issue with these is like, are there judicially discoverable and manageable standards for adjudicating the issue? And that's another thing, like, Eric, you kind of started to preview that issue. Like, how do you define what an adequate education is that is like specific enough to be able to tell whether or not a system is designed to realize it?
Yep.
And so like, that's a huge one that a lot of courts have said, like, we can't discover standards. Can't find standards.
But didn't they try to do it here? Because when it was remanded to the lower courts, the lower court in 2000 or 2001 said that the state failed to provide at-risk students with the opportunity to receive a sound basic education, and then ordered the state to fix it by providing pre-K.
Right. And that's what,
right?
Basically, this is the first hurdle
students
had to overcome, is this question of justiciability. And so, the court, it said, yes, this is justiciable. They gave a standard, and they gave the lower court that standard.
Right. And then the lower court came back and said, all right, in order to meet the standard, pre-K, right?
Yeah. So then what is that standard? What is a sound basic education in North Carolina, according to Leandro 1?
I used to know it, and it's not going to be able to be tattooed, but sufficient ability to read and write such that,
I have the direct quote. Do you want the direct quote?
Pulling from Rose.
Yeah. They copied it. No, they didn't copy and paste. They did the thing where you look over your buddy's shoulder and you rewrite it in your words, so it's not directly plagiarism.
Yep.
Right?
Yep.
But yeah, so like the Leandro 1, first they asked the question, like, is education an individual fundamental right under the North Carolina Constitution? Because remember, it's not under the federal Constitution, because the federal Constitution doesn't say anything about education.
Right.
North Carolina's does.
Yeah.
We've got these two education clauses. I'm going to read them because I think the language is really important. So the first one is Article 1, Section 15. The people have a right to the privilege of education, and it is the duty of the state to guard and maintain that right. I think that's pretty straightforward.
It's clear.
And it's in Article 1, right? So again, I'm on dangerous ground as a policy scholar, so I just want to tiptoe right up to this. But there's some folks in North Carolina who've done a lot of work looking at constitutional conventions, right? And sort of uncovered the fact that there are members of the post-Civil War constitutional conventions who advocated and worked hard to get that language in Article 1 as a more sort of treasured place of real estate for constitutional language, rather than something that's just enumerated in a laundry list of other obligations.
That's really interesting.
Yeah.
Yeah, because when we're talking about constitutional interpretation, especially with state constitutions, like the Constitution has to agree with itself, right? And so like typically what happens is the stuff that happens before is the stuff that controls over stuff that happens later in the document. So yeah, that's really interesting. I didn't even think about the organization of that.
Yeah,
totally.
And it says right. So like I think North Carolina had a pretty easy job saying like, is this a right? I don't know. What? I guess the text says it's a right. Oh, well, I guess there.
It's written right there on the box.
Yeah, but okay. Put a pin in that, because the next North Carolina provision on education is in Article 9, so a little bit later, Section 2, and it says, the General Assembly shall provide by taxation and otherwise for a general and uniform system of free public schools, which shall be maintained at least 9 months in every year, and wherein equal opportunities shall be provided for all students. So it says, wherein equal opportunities shall be provided to all students, and yet, Eric, you mentioned that this is an adequacy case and not an equity case.
Correct. Right. So out of that language, the court is pulling this right from Article 1 to a sound basic education, right? Which sort of does an end run around the equity question, but also like, gives up the wonderful breadth of that word opportunity, right? Which other states use to paper over a host of flaws in their school funding mechanism. So then you're just kind of sitting there, right? And the court's just kind of making that call.
Right. Yeah. And I think the way like this equal opportunities language, like it becomes more of like an equal access to a sound basic education. So like everyone should have the same opportunities, the same chance to get a sound basic education. But within that sound basic education, like, it's cool if some people are getting a better education than others, just based on local context or whatever it is, as long as everyone's meeting the threshold. Yeah. And then, to go back to defining that threshold, a sound basic education, I don't know if you have it in front of you, but you did you hit the highlights.
Oh, nice.
Yeah. Sufficient ability to read and write. I think it's probably from your master's thesis, right?
Yeah. Burned into my brain. Sufficient ability to read and write such that blah, blah, blah.
Yeah.
Sufficient ability to calculate and compute such that blah, blah, blah. Right. And I think there's a third. Maybe there
are 4. Yeah. Okay. So sufficient ability to read and write. And part of that is also sufficient knowledge of math and physical sciences to enable the students to function in a complex and rapidly changing society. Right. There's the language you needed.
Yeah.
Knowledge of geography, history, basic economics, political systems, sufficient academic and vocational skills to enable the student to successfully engage in post-secondary education or vocational training, and sufficient academic and vocational skills to enable the student to compete on an equal basis with others in further formal education or gainful employment in contemporary society. So like that's huge.
That's a lot of stuff there. Yeah.
Yeah. So if that's a sound basic education, I feel like that's a pretty high threshold, which is good, right? Yeah. Because I think those are all things that we can get some pretty wide consensus on.
Right. But also at the same time, it is likely not very surprising that that's difficult to meet.
Right. And it's not that surprising that it's difficult to decide if a system is meeting that.
Yeah.
Right?
Yeah, exactly. So basically, this takes us to Leandro 2, right?
Right. Because the court gave the standard and said, lower court, go see what you can do with that.
Right.
Yeah.
So they did that. They said, state, you need to provide pre-K to all these at-risk students. That's going to be the remedy. And the state was like, mind your own business. And they appealed to the Supreme
And this
Court.
is what, 2002-ish? Right? Is that where we're at?
I think so.
Yeah.
Wasn't it like a 14-month trial?
Yeah, it was a very short trial. And
wait, did you just say very short trial?
14 months. Yeah, given that after the 97 case,
compared to how the whole thing is going, 14 months is nothing.
Compared to this episode, maybe, I don't know.
Fair. After Leandro won, the case was basically handed to the Superior Court in the person of like this judge, Howard Manning, who held it longer than the trial ran, right? And so the interesting kind of thing inside of this space is that Manning continues to just issue statements and pronouncements about the case. And so he's actively engaged in thinking about these issues in addition to running the trial.
Got it. Okay.
Right. So, and I can't remember the timeline on it, but at some point he went into the Charlotte-Mecklenburg system and pulled out like 4 schools put them on notice based on their test scores and threatened that the state was going to shut them down.
Really?
For not meeting these adequacy standards, right?
Wow.
So yeah, there's a whole nother thing that could be written about just the personality of this judge who held it until 2015. And we can definitely tell stories. He would come to school finance conferences. He would argue with school finance scholars. I remember him and Craig Wood getting into it.
Yeah, that's my predecessor here at UF. Yeah,
we were
that's
talking,
amazing.
Yeah, so
I love to see that the judge is really invested, because one of the things that like people say about school finance litigation is like the judges are not experts, right? And so like it's nice to see that a judge obtaining that expertise. So like, yeah, that's really cool. But like all of this comes down to people, right? And that's, I think, a really fun aspect of the story.
It does. I mean, there's a lot of very colorful stories around Leandro that people in the legal and policy communities tell, right? So one of the apocryphal stories is about Judge Manning coming into his office and looking at these boxes of evidence and then deciding it's a beautiful spring day, and Houck County, one of the counties that was a plaintiff, isn't very far away. So rather than spending his day in chambers reading evidence, like goes for a drive, right? And rolls out to Houck County and just kind of putters around to see what's going on.
Wow.
What is the condition of the school system, right? And so there's a line in, I believe it's Leandro 2, where Manning says, you can have all these systems and have all this funding, but it's not really going to matter unless you have trained, competent teachers in every classroom, right? Something with that kind of flavor to it. And that's basically because he rode out to Houck County. He went into a computer lab, right? And the kids were working independently. I believe it was a weekend, and the teacher was taking a lunch break, right? And so Manning sees students without a teacher, finds the teacher kind of having a bag of potato chips, and comes to the conclusion that the problem is not a resource problem. The problem is a utilization problem.
Oh my goodness.
Right? And this kind of flavors Leandro too, right?
Right.
Yeah.
Because Jamie, you were talking about what Leandro True ordered. So like the trial court finds that the system is in violation of North Carolina Constitution. It's not providing everyone a sound basic education, particularly at-risk students.
And says you need pre-K. The state appealed, and in 2004, the Supreme Court affirmed the trial court's decision, basically saying, yeah, the state failed to provide a sound basic education, but they reversed the pre-K thing, right? And they said, that state, this is up to you to come up with the remedy, right? So the trial court's idea of what the remedy is out the window, essentially, and it's the state's obligation, according to the Supreme Court in 2004,
It's the state's obligation to fix it.
Yeah.
Right.
But they also hamstrung the state, right, in some really important ways. So they defined that sound basic education threshold wasn't being met. Something needed to happen, right? But within that ruling, they said, well, your curriculum and your curriculum delivery system is constitutional. Your funding mechanism and attendant policies is constitutional. Your accountability structure and its attendant policies are also constitutional.
Interesting.
So it's really a challenge, right? To
say,
say,
what levers do you have left?
You're going to fix the system, but you're not going to touch the accountability system, the curricular system, or the school funding mechanism.
So they're basically saying, the system is broken, but all of the system's subsystems are working fine.
Right. Or that you don't have to mess with those.
Right. So you see them hanging things on the outside of the policy structure. I guess that's the image I have in my head. It gets to Jamie's point about pre-K.
Yeah.
Right? Yeah. Like, let's just hang something else onto the system, add something to the system, rather than like popping up the hood and changing something under the hood of the system.
Okay. Which raises like the really interesting questions about separation of powers, which is kind of what, everything from here on to today is all about. Like, if there is a violation, who gets to fix it?
Yeah.
And the court in Leandro 2 kind of says like,
it's the state,
it's the political branches, like they get a chance to fix it. But they also in Leandro 2 kind of foreshadow some like, we mean it, guys, language.
Right.
Because at one point, the court said, at this juncture, a premature judicial encroachment on a core function of a state's legislative and executive branches. So like, they're basically saying like, hey, we're going to say, no, you don't we can't mandate pre-K because that would be an infringement at this juncture. And like, I love the foreshadowing of that because the court is basically saying like, fix it. But if you don't,
or else
we're coming.
We're gonna.
Right. We're not joking.
No. Yeah.
Well, and that's where like a lot of courts have tripped up, right? Like, so I'm from Ohio.
Oh yeah.
And we've got the DeRolf litigation, which was like 97 to, or, you know, it was filed in the early 90s. And the Supreme Court of Ohio basically just washed their hands because they said like, hey, this system is unconstitutional, fix it. And then we had DeRolf 2 and they're like, no, like keep trying to fix it. It's not fixed yet. And then DeRolf 3 and then DeRolf 4, where the Supreme Court was finally like, well, we're not sure if it's fixed, but we don't have jurisdiction anymore. And they kind of just washed their hands of it without ever saying like, yes, it is fixed.
Side note, does this have any similarities or parallels to, say, for example, the Swan versus Charlotte Mecklenburg case where, you know, that was a desegregation case, but it wasn't about the segregation itself. It was about the court's authority to remedy desegregation, right? So it sounds like there's a little bit of a parallel there, that these sort of questions about jurisdiction do pop up in lots of places, you know.
Right.
Right?
No, I really like that.
So I think this all takes us to Leandro 3, right? Which is like 2013.
Right. And
13 or 14. Yeah.
Leandro 3, like, I feel like this is the sequel that isn't quite as good as the first two, but also isn't as good as the next one, right? Like, this is the Star Wars Attack of the Clones, right? Like, it's right in the middle. It's not as good as the ones that came before it. It's not as good as the one that's going to come later.
Right. I think of the Bourne movies. I mean, I think it tracks well with the Bourne movies as well.
There you go. Yeah. This is but like, not to downplay the significance of it, right? Because, you know, this case is still going on. And it's still like people are fighting about what it means and what to do about it.
Yeah. So things get interesting, or remain interesting and complicated with Leandro 3. So the state is taking its sort of mandate to try to fix this. And it's saying, all right, we're going to try to expand pre-K, right? But then the General Assembly comes along and limits access to pre-K, right? So the court said that was like not cool, right? And the state can't do anything that would deny eligible at-risk students pre-K.
Right, which is part of the remedy to fix this whole thing, right?
Right.
That's what everyone's doing. But that gets all the way up to the Supreme Court. And at that point, like, the legislator had changed the laws, right?
The General Assembly changes the legislation. Basically, it's bouncing up this sort of legal ladder, right? And the Supreme Court, because the General Assembly made those changes as it was going through the process, the Supreme Court at that time just kind of tossed it all out, saying that because those legislative changes were made, the case is now moot, right?
Or that challenge to the changes to K-12 or pre-K, right?
Yeah.
But like, because the Leandro, like, the have you fixed the unconstitutional system, that's still going on.
Right.
This was just one piece of that bigger question.
Right.
Which
is that right?
To,
like, is that an adequate sort of interpretation, Eric, as to sort of what's happening around that time?
I mean, I think so. I think for me, conceptually, it gets really muddled through here.
Yeah.
Right?
Yeah.
So like, I'm just kind of like, okay, that's a better articulation and signposting of it than I could do. There's Leandro 2, a lot of crazy shit happens.
Right.
And we end up at Leandro 4, right? I mean, and coming from a policy perspective, I guess my milestone through all of this is that in 2015, Judge Manning retires.
Okay.
And that's when Lee comes. Is that when Lee comes on?
Yeah, exactly. And Lee gets appointed to hold the case and then moves it in a different direction, right?
And that's when
studies and like the West Ed report.
Yeah,
I was going to say that's when everyone hires a external consultant to come in and say, okay, what would it take to make this system compliant?
Right.
Exactly.
Right.
Yeah. So basically, everything gets muddy. Judge Lee comes along around 2017, 2018. The governor establishes this Leandro Commission. They get this, they commission West Ed to kind of look into everything as an independent consultant. And they kind of charge him with, okay, look at this whole thing and give us some concrete recommendations or actions so that we can be in compliance with the constitutional mandate. Right?
Yes.
Mm-hmm. And then in December of 2019, I remember that was my first semester as a professor, and I was about to start teaching school law the following semester. And this was like huge news in North Carolina when this West Ed report came out, right? because there's this major development in this, at the time, 25-year-long Leandro case, because now all of a sudden we have these, 7 or 8. And it was the stuff that like Manning was saying, right? Like, you need to have a competent teacher in every classroom. You need to have a competent principal in every building, blah, 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 right? I think
the gallows humor was, the West Side Report was 1.7 billion specific recommendations for how North Carolina could fix it. Yeah. Because that ended up being the bottom line, right?
Yeah.
The price tag.
Right.
Exactly. That was a $1.7 billion price tag. And they did, I think you said that really well. Like, they took all of these sort of statements that Manning had been making while he held the case kind of through Leandro 3 and operationalized them, right? Into some like specific programmatic recommendations with the price tag.
And kind of backed it up through, some rigorous kind of research and...
Quite rigorous. Yeah, for sure.
Yeah. So it wasn't just, some guy who said, I'm no education expert and I think this is what needs to happen. Now you've got these education experts saying, you know what, that guy was right.
Right. Yeah. And it was really credible and everyone agreed and everyone followed it. And the legislature allocated $1.7 billion to fix it.
Yeah. And thus ends the episode.
Right. Hey, under an hour. We did it.
Look at that.
Wait a second. No. Oh, is this the world that also won the lottery?
So as most of our Chalk and Gavel listeners know, that's not what happened.
Right. No, we've got at least one more case and about to be a Leandro 5, right?
Yeah, I think, right?
Yeah. Probably. Right. So that leads us to Leandro 4. This report comes out and it's a settlement agreement at this point where basically the plaintiffs and the state defendants agree to implement the recommendations or some version of the recommendations with a $1.7 billion price tag. And so that everyone agrees that if the state does this, that fixes everything, and the court says, goodbye us, go for it. And then the legislature steps in and says, wait just a second, you want us to pay how much?
Yeah. And they weren't happy about that.
And they refused to pay it, right?
Yeah. And so this is where things, when I was following it as a new education law professor years ago, this is where things got really fascinating to me, because Judge Lee turns around to the state in November 2021 after the state says, yeah, we're not going to do that. And he turns around and says, well, you know what? We, the court, are now going to order you to pay that $1.7 billion.
Right. And that is something, as far as I'm aware, and Eric, correct me if I'm wrong, no court had ever done.
It's the place that nobody wants to go, right, in these school finance cases, because it asks the very obvious question, what authority does the court have to impose its will on either of the other two branches? The court has the power of persuasion, but it doesn't have the power of enforcement.
Right.
And
that's where the legal question sort of everything got crazy at that point, because the state controller was like, hey man, stay in your lane. And so that's when the case turned into this, another sort of layer of this jurisdictional kind of...
becomes a standoff, right?
Yeah.
Right. So to be clear, the legislature refused to fund the remedial plan, right? The court orders the state controller to release funds. I mean, to make a disbursement.
Right. Because they're calling for $1.7 billion investment in public education, but at this point the state was sitting on an $8 or $9 billion surplus. So the state has the money, and that's not the question here. The question is what do you do with the money that the state has?
Yeah, and so then it's really interesting because not acting independently, but somewhat acting independently, the state controller says, I don't think you can make me do this. Right. So actually, that's a different case, right? So that's not a Leandro case where you're kind of duking it out in this is a different case where the state controller is suing to say, I don't think I can take orders from the court. Right. And then that's the case that really drops the control rods in all of this.
Right.
Okay.
Right? Where they say, no, you're right, you can't do that. And then you have the standoff.
Right.
Got it. Okay. And that leads us to the North Carolina Supreme Court Leandro 4 decision in 2022, which is when the Supreme Court comes back and says, look, it's our job to enforce the Constitution, and this is in the Constitution, this education clause. Therefore, this is our authority. We have the authority to remedy constitutional violations. Mm-hmm. If this is the only way to get this remedy to work, we say we have the power to do it. And that Ooh, the phrase I have in my notes is the court throws hands, because like that is like the court is stepping up here in a way that a lot of other courts haven't stepped up, because it raises such fundamental questions about the role of the judiciary and separation of powers and like, you know, the authority of courts, because like courts can't enforce their own edicts. So if somebody just decides, I'm not going to follow that, like we as a country don't have a great answer for what happens next.
Exactly.
Yeah. And you know what the other thing is, I think it's important to kind of highlight here that at this point, the case had gone beyond these 5 rural counties and the handful of the urban and wealthier districts as well that had signed on to it, because one of the questions that the court in Leandro 4 answered was there a statewide violation of the Constitution? So they by this point, it has expanded to, you know, is this a problem statewide as opposed to is this a problem in a handful of counties? So there were 2 questions that Leandro 4 asked and answered, which was there a statewide violation of the Constitution? And do the courts have the authority to order the state to pay? And like Chris said, the answer in Leandro 4 was yes and yes, basically, right?
Which is an interesting contrast because, you know, between like 2004 and this action like 2018, like it's a long period of time, right?
Yeah.
And so what you saw Manning doing was trying to narrow the case.
Yeah.
And kind of when Lee comes on, he just blows it up.
Yeah.
Well, he, you know, I don't think he did it by himself. I think the legislature actually helped him by escalating this fight. Like everybody wanted this fight in the crazy years, right? I mean, when things were just complicated and weird, Manning is saying like, we're just going to look at Hope County. We're just going to have a hearing on Hope. They're going to represent the plaintiffs and Charlotte's going to represent the interveners. And he's kind of trying to narrow this thing down into something manageable.
Right.
And once it gets out of his hands, it becomes a broader issue coming from the Lee court, but it also becomes broader because the legislature
is making it broader.
Is making it broader, right?
This is the first time the legislature has intervened as a party, right? Like before this, and that's one of the arguments they're making is like, look, before this, we didn't have a voice and we're the purse strings. Where were we, guys?
Right. It was like the unified state. And now what you see is the executive and the legislative fracturing off, which of course reflects the governmental control of the political parties in the state, right? So the executive branch was run by a Democratic governor and the legislature was a Republican supermajority at the time, right?
Oh, okay.
So feeling themselves, right, going through redistricting in a way that advantaged them as any party in power does.
Right.
And so having something like a supermajority that's veto-proof, they're able to assert themselves a little bit more distinct from the executive.
Right. And to add another wrinkle, the Supreme Court at this time what's the ideological makeup of the Supreme Court?
It's majority Democrat.
At the time.
At the time. And this
in
decision,
2022. Yeah. Okay.
This decision came down in like the first week of November in 2022. And what happened in the second week of November, 2022, was there was an election.
Right. And what is it? 2 of the justices in the majority lose re-election or aren't on the court anymore?
One retired and one lost?
Retired.
I can't remember, but all that I remember is that the makeup of the Supreme Court in North Carolina switched a week later.
Okay.
After this decision.
That, I think, is some really interesting context here because Leandro 4 says we, the Supreme Court, as the judicial branch of government, have the power to tell you to spend this money to remedy a constitutional violation. And they don't equivocate, right? Like they are very direct, like, no, this is our inherent authority to do this thing. And they make a really interesting separation of powers argument that I think is really fascinating and really kind of makes a lot of sense. They say that like, yes, this does seem to implicate separation of powers because we are telling another branch of government what to do. But they go a step further and they say separation of powers also prevents any branch from stepping on the toes of the fundamental role of another branch. And our fundamental role is to say what the law is and to enforce the Constitution. And so therefore, if you aren't doing what the Constitution says you're doing and you refuse to remedy that violation, then like we as the court, that's our core role. We have to stop you from violating the separation of powers by telling you what to do, implicating the separation of powers. So like, it's a really smart argument that I actually like, you know, it makes perfect sense because if the court says what the law is and is the branch that we rely on to ensure the constitutionality and that, to remedy these constitutional violations, we can't just allow the legislature to keep violating students' rights to a sound basic education.
And yet,
I was going to say, and there's the transition to Leandro 5.
So basically what happened was it sounds to me, and this is where things kind of get a little muddy to me, because reading up on what's taking place around Leandro 5 and right now seems to be like there's a lot more, they're throwing around a lot more legal technicalities like that seem to be avoiding some of these bigger questions.
Right. And that is 100% it.
Is that an accurate way to look at it at this point?
Yeah.
Because it just seems like at this point, all of a sudden, the Republican supermajority in the legislative branch here looks at the fact that we now have a new dynamic on the Supreme Court and says, well, you know what? Let's try this again.
Yeah. Round 2, or in this case, round 5.
Round
right?
5, right?
Yeah.
And so basically they try to kick this thing back to the Supreme Court, even though the Supreme Court has already decided on it.
Right. But they can't do the same thing, right? So like they've got to figure out how to make it different enough, or to how to like basically poke holes in the entire case. And that's kind of what they're doing here.
Yeah.
So, this is where I want to phone a friend and get somebody who knows North Carolina civil procedure way better than I do, because like they're making procedural arguments, essentially. We've got this Supreme Court decision in Leandro 4. It goes back down, and like the trial court's trying to implement Leandro 4, and there's a ton of more fighting about all these little jurisdictional questions. And so it gets appealed to the Supreme Court again, and the Supreme Court agrees to hear whether or not, there are fundamental flaws in this case, and whether or not the Supreme Court even had the authority to decide this case in the way that it did. Yeah. And so there's a number of different kind of like arguments here that are more kind of like procedural rather than substantive. And so the overarching issue is like, does the Supreme Court have subject matter jurisdiction over the case? So, subject matter jurisdiction basically just asks whether the court has the authority to decide the case and issue a remedy. So the legislature is making a number of different arguments about why the court doesn't have authority and can't issue a remedy. They're arguing that like this entire case is about Polk County and just, the 5 districts and the intervener districts. And therefore, because it's just about the education there, the court never found a statewide violation, and therefore it can't issue a statewide remedy. So like any remedy needs to be specific to those counties.
Didn't they also, like, I remember listening to the argument last year, and weren't they even saying things like, but wait a second, all of the moving parties in the original case,
right? The students are gone.
They're not even students anymore. So this case isn't even, it should be moot.
Yeah.
Right. Yeah. And so they're making mootness arguments, basically saying like all these kids have graduated, and why can school districts sue the state? Aren't school districts like
part of the state,
part of the state, arms of the state,
right?
Creatures of the state. And yeah, that's another one. Another argument is that this isn't an adversarial process, or like for decades, this hasn't been an adversarial case because courts can only hear so-and-so versus so-and-so. And here we've got like the legislature is basically saying like, oh no, the executive and the schools were in cahoots to make us pay too much money. And so like, it's this argument that like it's a friendly case, and we, the legislature should have been a part of it for way longer than we were. Yeah. And because we weren't a part of it, we need to redo this whole thing. Yeah. And like, there's so many different things, and, they're not just challenging the procedural stuff. Like all of this is also getting at the substance, where basically like they want the court to say that we got it wrong in Leandro 4.
Yeah. Right.
But, courts are typically hesitant to overrule themselves, particularly that quickly, right? Like the only thing that has changed between 2022 and 2024, when they're hearing the oral arguments for Leandro 4, is
the makeup of the justices.
And that's a really bad look, because we like to think that courts are above the political fray, right? Like the fundamental thing about courts is like everyone should feel like they're getting a fair shake.
Yeah.
And if the only thing that changes is the ideological makeup of the court, and that changes the outcome, that seems to indicate perhaps that the courts are just another political branch.
Right.
And that is, as the dissent in the decision to take up Leandro 5 would say, that's a bad look.
I'm just going to be an ignorant party here in terms of, school law makeup across the 50 states, right? But are all Supreme Court justices at the state level elected, or are there appointment models as well as election models?
I believe there are appointment models as well as election models.
Yeah.
But don't quote
that's
me on
an
that.
interesting dynamic, right? Because Supreme Court justices are elected in North Carolina, and this is what caused the court to roll over. And so it gives even more credence to what you're saying, Chris, because it's undercutting the objectivity of the court, because it's making the court part of the warp and woof of the political cycle.
Right. Yeah. And so there were a couple justices who wouldn't have taken up this case because basically they said, look, we answered all of those questions already. You're just trying to relitigate this thing now that you think you have a more receptive court. And those dissenting justices actually quote extensively from the dissent from the United States Supreme Court's decision in Dobbs versus Women's Health, which is the case that overturned Roe v. Wade, right to an abortion. And they basically say, like, this smacks of rank politics, right? Like, if the only thing has changed is the makeup of the courts, that's not a good enough reason to retake up this case. So this is a really interesting wrinkle to all of this because we don't know, it's been a year since the oral arguments where they kind of threw all of these potential issues or hangups or, roadblocks up on this case. And we don't know what is going to happen now with the new court. And it's been a year since the oral arguments and we haven't had a decision, which feels like a really long time.
Yeah. Currently the court itself is contested, right? So there was an election in November, which has not been settled. So it wouldn't change the majority of the court, but it would change the valence of the majority of the court, right?
Interesting.
So a Democratic judge was reelected with about 700 votes across the state, and the Republican opponent for that seat on the court is litigating the election, right? Actually trying to invalidate, I think, 60,000 votes because the voter applications have incomplete information.
And I think
so there's other political things going on
so
too,
it is,
right?
Yeah. So so there isn't actually a court to speak of at the moment, right? And because this question is being litigated as well.
And I think to answer your earlier question, about how this process plays out nationwide, because in North Carolina, the state Supreme Court justices are elected in a partisan election, which means we know what party
That's an important point.
Right?
Yeah, exactly.
Because some elections are nonpartisan. So you basically, in those states, you're electing...
Well, they don't have an R or a D next to their name, but everyone knows who they're campaigning with, right?
Yeah. I mean, if you do the research, you can probably figure it out.
Right. But you don't just vote up and down the ballot R or D or whatever it is.
Right. But it seems, my understanding is that there's only a handful of states that are partisan election states.
Or Supreme Court justices?
Yeah, for Supreme Court justices. I think it's like North Carolina, Alabama, Texas, Louisiana, Pennsylvania maybe, or New York, Pennsylvania, maybe Illinois. I don't know.
New York always does their own thing.
Yeah. Yeah, they don't even call it a Supreme Court in New York.
Hey, they stole Kentucky's definition too, right?
So for the Rose?
Citizens, so you can draw a line, this is an aside, but from Rose to Leandro to Citizens, I forgot the name of the school finance case in New York.
Yeah.
Pulled the same language. There's a really nice through line across all three cases.
Oh, that's funny.
Yeah. So I think most states are done by either gubernatorial or legislative appointments, I'm pretty sure. So anyway, it's an interesting thing to talk about because these kinds of cases are playing out in so many states. And it's, I guess this is one way to look at it is depending on where these conversations are playing out, how the people who are making the decisions get into the decision-making positions in the first place,
right,
could have a significant influence on the outcome.
It could, especially if there are potential recall opportunities, right? Or like, if you go up every so often for a vote of no confidence or whatever it might be, like if we are electing these folks, then there's a certain, maybe your considerations shift, right? Like instead of being purely about what the text of the Constitution says, now you're thinking a little bit more like a politician.
It adds more chaos into the mix, right?
Yeah. No, and I think that that's one of the things that I take away from the Leandro story and school finance in general is this is all politics, right? And it's all really, really complicated because it is both fundamental, right? Like everyone wants kids to have a good education. And that's one of the things that listening to the oral arguments in Leandro, what will be Leandro 5, the attorney for the legislature comes up and says, this isn't a case between those who want to fund schools and those who don't. Like, it really kind of highlights, that's such an important thing, but then it raises all these complicated questions about like, who gets to decide, who has the authority to decide, and then that all comes down to people, right? And the people are where the story really takes place and where every state kind of takes on a different flavor.
So where does that leave us? We said it on the last episode. Dogs and cats living together, mass hysteria, which seems like it's probably going to be a Chalk and Gavel theme for the next little while. But like, where are we at? Well, we're waiting for the current Supreme Court to decide and to make a ruling based on those arguments.
To basically see what's going to happen to Leandro 4, right?
Yeah, based on those arguments from a year ago. Like thinking about, Eric, like the school finance classes that you teach and working with prospective school leaders and district leaders, like what would you say are the big takeaways from a case like Leandro and sort of school funding in general? What does Leandro what does it tell us?
I think Chris is onto something as a first point. So much of
for
this
the
is
first
politics.
time is what I thought you were going to say.
Really? Is this? Are we making news here? As someone who's a scholar of leadership and policy, you don't want to boil down everything you do and everything you study to sort of like, well, everything's a bare knuckle fight. It's politics, right? All the way down to the bottom. And yet, when you look at this case as it's gone on since 1997, it's
like, how can you see it any other
politics,
way? Right. Yeah.
Right.
But within that, though, there's been a lot of compromise and there's been a lot of like.
There's been a little bit of movement, and I think some of that movement is politically aligned as well. Sure. Would be the counter argument. The state did institute, because of the pressures of Leandro, an additional funding mechanism. The Disadvantaged Student Supplemental Fund provides additional money to districts with high concentrations of low-income students.
Nice.
Under some threat from the case, the state implemented a low-wealth school fund, right, which looks at the fiscal capacity of districts to raise money, which is the first time from the school finance perspective, right? This is the first time that North Carolina has acknowledged a connection between state and local funding, which also is different from a lot of other states that require a local contribution or a local match or required local effort in order for the funding mechanism to work. North Carolina's never had any language like that at all, ever whatsoever.
Oh, wow.
Which is interesting, not to go too much on a tangent, but Chris, in the early Leandro cases, the state's position was, we, the state, are doing everything right. We're on the side of the angels, but there are these local school districts and we can't control them. They're going to do what they're going to do. And any inequities in funding or inadequacies in funding lay at the feet of these local governmental units.
Right.
Flash forward to now, where the state's argument is, hey, we're not in a fight because the locals are an instrument of state power. Like, we're all on the same team, right? So even over time, like, the conception of how government's constructed has changed.
Right. That's really interesting. Yeah. And it raises questions of causation too. Like, so is it the lack of money that is causing the lack of a sound basic education, right?
Right. Exactly. I think the other thing I tell my students too is that so much of this stuff just hangs together on our shared understanding of what's happening, right? We talked about North Carolina having this sort of restrictive resource allocation model, but even within that model, like, one phone call with your chief finance officer can dramatically change how your school gets funded or what they're able to do to get funds from the district to the school or from the state to the district, right? And a lot of this stuff, and I think Leandro kind of leans in on this, is not politics in the capital P Democrat versus Republican way, but politics in the little p, I went to
relationship building.
I went to the barbecue with your mama, right?
Yeah,
How are I'm a school and I want to do this. Is there room for me to do this? Right. Within the web of the system, and people find space to do that.
So it's the relationship building. It's getting involved. It's being aware of
articulating your point, advocating your point. Even if you think you're talking to someone who's going to give you a no, because you just don't know what you're going to say or how you're going to say it, that might unlock an opportunity for you.
What you were talking about kind of reminded me that as educators, if we look at it like it's okay to get political with a little p, right? Because it's likely the political with a big P that makes everybody all uncomfortable and I don't want to be that, right? That's not why I got into education. If I wanted to do that kind of work, I'd go into politics with a big P, and I'd be a politician with a big P. But it's oftentimes I don't want to say a lack of understanding, but it's just a recognition that there is a little p politics, and I can actually do a lot of good and try to meet my educational aims and goals if I can get little p political. Is that a fair?
Yeah, no, I love that, because it gets back to what we've talked about a lot on the show about like relationships and, working within those to accomplish your goals and to like reach consensus. So like, it doesn't have to be that bare knuckle fight, right? Like if we build those relationships, if we develop those things, then hopefully we can mitigate those bare knuckle fights from ever even happening.
Right.
Yes.
Right.
I mean, just to put it on a little bit of a different metaphor. So an observation and then a restatement, I think, of what you just said, right? The observation is working with educational leaders. One of the things that I always stress is a lot of us came into education because we had good experiences in education, right? Which leads to biases when we're dealing with populations who didn't or might not be having good experiences with education, right? And one component of that is a real respect for the rules and the rule structure of educational institutions. Right. And so to kind of look at that with fresh eyes is one of the things I encourage leadership students to do. Just to change the metaphor somewhat and to restate it somewhat. As a father who has daughters, right? One of the lessons we're always trying to impart upon them is like, when you go into a situation, like make somebody tell you no. Don't assume the no is there, right? And talk yourself out of it. Right. Go in there, hold your head up. Yep. Let the other party feel uncomfortable telling you no. You don't feel uncomfortable asking, put the burden onto them. Mm-hmm. And I think there's some lesson in that for training educational leaders within these systems. The no is not chiseled in stone. It's never permanent. There's always something you can push on in a loosely coupled system that scales the way that education does.
And we talk about that in the law all the time. Like it's like not black and white.
Right. And to use a quote that Jamie used in another case that we did, you miss 100% of the shots you don't take.
Right. Right.
I pulled that from somebody else.
Yeah. Well, to elevate it a little bit, right? There's the Leonard Cohen quote, right? There's a crack in everything. That's how the light gets in.
Ooh.
You know what? I didn't even know.
I like that.
I always knew that you had great taste in movies, and now I know you've got great taste in music and poetry.
There's a whole other podcast we can do.
Oh, man. Well, listen, as a Canadian, we have to like Leonard Cohen. But anyway, I listen. I think that's a great place to leave it because this is a long episode already. Those are really good points that kind of round this out and bring it back. But I want to take the opportunity to say from the bottom of my heart, Dr. Houck, thank you so much for joining us. It is amazing to see you again. We greatly appreciate the time that you have spent with us today and your insights and your experience and expertise, which is probably in the Leandro realm, I would say unmatched. Yeah, that's fair to say. So thank you so much. Thank you.
I appreciate the time. Y'all, this has been a great conversation. I've learned stuff. I really appreciate it. It's been a blast.
Can
I come back after Leandro 5?
Absolutely.
We're going to have to do an update.
Yeah, we got to do an update. Yeah, you can come back.
Fair.
Thank you.
Good.
Which, who knows when that's going to be? It could be next week. You could be on for the next episode. We don't know.
I haven't even got my shirt back from the cleaners.
All right, Chris, do you want to give us our homework?
Your homework is to not spend the next 30 years listening to this episode, though we would love it if you continue to engage with us. It probably feels that way sometimes. Is to continue to engage with us on social media. You can find us at chalkandgavel.com. We also have our teaching guide up there. So if you are teaching school law and you need resources, check out our teaching guide at chalkandgavel.com. If you like what you hear and you want to support the show and help us continue delivering the education law content you know and love, you can go to our Patreon page, patreon.com/chalkandgavel. You can become a subscriber there. That goes a very long way to helping us support the costs of doing this this project that Jamie and I love, and to help us continue to grow and do exciting things like having guest experts on who know way more than we do.
Yeah.
So check us out there as well. We need all the help
we can get, people.
When are one of those coming on? When's that happening?
Well, thank you again, Eric. We appreciate it so much.
Yeah.
That was a blast.
All right, everybody. Well, with that, we will leave you and see you again in 2 weeks. Have a good one, everybody.